that any remedy lay not with this court but the Minsk process. Both of these submissions were rejected by the Grand Chamber. After that judgment, however, the respondent recast its position on exhaustion for the first time and claimed that the applicants were always at liberty to enter Armenia and NKR to lodge claims. No explanation was proffered. We say that's because the respondent still held to an administrative practice that denied Azeri refugees the right to return. But in order to make its 2012 submission work, it was forced to make a vacuous distinction between Azeri IDPs as a class of people who wish to return to their homeland and those individuals who may wish to return to exercise their individual rights. That, with respect, is a distinction without intellectual import. The established rule is to consider exhaustion when the application was lost, and there is no retrospective legislation here to address historical wrongs. Therefore, there is no basis for departing from the normal rule. More to the point, it ill behoves the respondents to suggest the applicant should have known that they were at liberty to return when its own representatives did not even make this point until 7 years after the application was lodged. Even if that were not the case, the Armenian Land Code does not begin to adequately address the violations suffered by the applicants. It cannot possibly convey the separate and additional right to return home to enjoy one's personal property and private life. The submission that these provisions amount to accessible and effective remedies, like its submission as to the relative ease of travel by persons of Azeri ethnicity to Armenia, are devoid of credibility. So too is the complaint that they rely upon abstract arguments about minefields, settlers, and the absence of diplomatic relations. That are real borders for IDPs. As to the human rights defender capacity, the defender has singly failed to do anything to alleviate the plight of the applicants, and we point to the UN Special Rapporteur's report concerning the office and its dwindling organisation. That leaves the purported independent nature of the judicial system. This very court has expressed serious concerns in several cases as to the independence and effectiveness of Armenian courts. One need go no further than to the respondents' silence concerning a question posed by this court as to whether any documented examples of Azerbaijan's citizens of Azeri or Kurdish ethnicity were able to return to the district of Lachin to obtain access to their properties. We say the respondent's new claim of exhaustion is about as dissembling as its claim to operate a dual passport system in circumstances where it hasn't even diplomatically recognised the NKR as a state. Mr. President, we submit this case tests the Convention's ability to protect the rights of the most vulnerable. More broadly, there lurks a spectre of violating states being given a roadmap by which to avoid Convention obligations. The respondent seeks to hide behind a vacuum it created. This should not be allowed to stand. My client's journey has been a remarkable one of hardship, but also in the faith of Europe. It is a journey that has led them to this Grand Chamber. All they ask is for this court to apply its rule equitably, having regard to their status and the Convention's special character as an instrument of European public order. If this happens, we have little doubt that this court will see fit to uphold their claims, thereby vindicating the legal and political purpose that this Convention was designed to serve.
Mr. Mark Müller, I give the floor to Mr. Swarup. Is that correct?
Yes.
Yes.
I shall address the law and facts in relation to the effective control case. The applicants maintain an alternative state agent case as set out in the written submissions. For brevity, I shall abbreviate Nagorno-Karabakh to NK. The law as to effective control is now well established. In Al-Skani, this court repeated that a state's Article 1 obligation to secure the rights and freedoms set out in the Convention derive from the fact of a state's effective control over an area, whether it be exercised directly through the contracting state's own armed forces or through a subordinate local administration. Where the fact of such domination over the territory is established, I quote, "It is not necessary to determine whether the contracting state exercises detailed control over the policies and actions of the subordinate local administration. The fact that the local administration survives as a result of the contracting state's military and other support in itself entails that state's responsibility for its policies and actions. The rationale for the effective control principle is the effective protection of human rights. There should be no human rights vacuum within the territory of one convention state, such as Azerbaijan, which is controlled by another convention state, such as Armenia. Furthermore, a state which agrees to the convention and which then chooses to create or sustain a separatist regime elsewhere should strive to secure the convention rights within that territory. As to the respondent's case, in its July 2012 submissions, after 5 years of this litigation, it has sought to introduce the novel argument that effective control implies detailed direction or control over specific operations of the controlled entity. This court has never said or implied that, but it has stated precisely the opposite on numerous occasions, including in the passage that I just quoted from Al-Skani. In Loazidu, the court held that Turkey was responsible for the acts of a separatist regime in northern Cyprus because, regardless of detailed control, it had overall control over that area of the island. See in particular paragraphs 52 to 56 of the judgment. And in Ilashku, the court held that Russia was liable for the acts of a separatist regime in Moldova because, regardless of detailed control, it had effective control over the relevant territory, based primarily on the presence of some 1,500 troops, the provision of weaponry to the regime, and certain financial support. See in particular paragraphs 315 and paragraphs 386 to 393 of the judgment. In support of this novel argument, the respondent also cites certain non-ECHR material, such as the ICJ Nicaragua judgment relating to general principles of attribution of state responsibility. That material does not assist. The precise issue here is the construction of the word jurisdiction in Article 1 of the Convention, rather than the general public international law principles of state responsibility, which themselves, as evident from the respondent's own material, are not settled. In any event, this court is entitled to and should continue to construe Article 1 precisely as it has been doing, that is, with special regard to the purpose of the Convention as an instrument for the protection of human rights. There is no reason for this court to overturn its clear, settled jurisprudence. As to the facts of the case, they are even more compelling than Ilashku. I refer to the evidence cited in paragraphs 41 to 84 of the applicant's October 2013 submissions and highlight 8 matters in particular. First, in a March 2010 newspaper interview, the respondent's president, Sargsyan, stated that in certain circumstances, the respondent, quote, would consider the return of the security zone regions around NK, which regions, of course, include Lachin. The respondent could only consider the return of those regions if it controlled them in the first place. Secondly, various international sources have described NK and the surrounding areas as being occupied by the respondent. For example, a January 2012 European Union information note referred to, quote, the occupation of 20% of Azerbaijani territory by its neighbour. Thirdly, there is the analysis of the world-renowned International Institute of Strategic Studies. Its 2013 report concluded, quote, since 1994, Armenia has controlled most of NK and 7 adjacent territories of Azerbaijan, often called the occupied territories, and that Armenia provides political, military and economic support to NK. Fourthly, the 2008 analysis by Charles Blandy from the Defence Academy of the United Kingdom, which concluded only 8,500 citizens from NK serve in the NK army. Some 10,000 come from Armenia. Between the armed forces of Armenia and NK, a high degree of integration exists. Yerevan supplies arms and other military necessities to Stepanakert. The support offered by Armenia is an open secret, yet Yerevan maintains that in NK and in the occupied Azeri territories around NK there is not one military subunit. Fifthly, there is the 2005 report from the International Crisis Group. NK is highly dependent on Armenia for its military security and economic survival. Over half its army are believed to be Armenian citizens. Yerevan covers 50% of the budget through an interstate loan that is virtually interest-free and unlikely to be paid back. The respondent attempts to discredit that report by producing a statement from one of the sources, Mr. Richard Giragosian. However, that statement does not actually withdraw the opinion Mr. Giragosian apparently expressed. Instead, he insists that in Karabakh there are definitely Armenians serving. Sixthly, there is the visit by President Sargassian to NK in 2012 and 2013. He undertook that the Armenian army would never be, and the defence army would never be short of any material resources, and promised that NK would have the most contemporary combat weapons. Seventhly, as the respondent accepts, Armenian passports are issued to individuals living in the disputed area. Finally, the respondent has established a trust known as the All Armenian Fund, which is a further means by which it provides financial support. Thus, there is independent, consistent and authoritative evidence that the respondent has a substantial military presence in the disputed area, that it supplies weaponry to NK and trains its soldiers, that the NK military is dependent for its existence and its effectiveness on the respondent, that the respondent provides financial support and other support. And without all of the above, the NK regime could not survive. The respondent bears a heavy evidential burden to rebut all of this material. It has not done so. No documents. It relies heavily on the so-called expert evidence of Dr. Bukur Marku, which in itself is based on undocumented alleged interviews. The witness evidence relied on is not independent, is not detailed, not corroborated, and is largely directed to the wrong legal test in any event, that of detailed control. In summary, the NK regime survives only as a result of the respondent's military and other support, and the respondent has effective control. To hold otherwise would be to cover up the respondent's open secret and to open up a human rights vacuum within the territory of the Convention.
Thank you, Mr. Swaroop. I call Mr. Ivers.
Thank you, Mr. President. With respect, we agree with the Chamber's judgment that the issues of jurisdiction, remedies and merits are connected. Evidence in respect of one can clearly be concurrently relevant with respect to others. And with this in mind, I turn to the merits. I'm going to make 5 points. The first one concerns the standard of proof. The respondent government quote Orhan, which establishes that proof must be beyond a reasonable doubt. But the matter goes a little further. As was stated there, such proof may follow from the coexistence of sufficiently strong, clear and concordant inferences, or of similar, unrebutted presumptions of fact. And in that context, the conduct of the parties whose evidence is being obtained has to be taken into account. Tanis tells us that this Chamber must view what the applicants can provide evidentially against the uncontroversial, albeit pre-ratification, factual backdrop of a last-minute flight for safety, an immediate militarisation of the region, and their position as refugees ever since. And as the Court has recognised, too inflexible a standard simply rewards the more effective perpetrators of violations for the extent of control they exercise over the ability of the claimants to obtain evidence. The applicants have submitted, secondly, the merits, have submitted sufficient evidence to show that they owned or had the right to use the property from which they were displaced in the several rounds of written pleadings to date. We have provided detailed submissions and evidential annexes concerning their ownership of property on no less than 10 occasions,